I would take the liberty of straightway starting with the next session, which is the last session of the day. This particular session deals with judicial appreciation of digital evidence. And the resource person for this particular session is Madam Harshali Chowdhary. Madam Chowdhary is on the faculty of Chandigarh Judicial Academy. She has joined the Haryana Judicial Service in the year 2006. Having exercised different jurisdictions over the years, in the year 2018, she was promoted to the Haryana Superior Judicial Service in 2018, and she became the additional district and session judge. After that, 3 years later, in the year 2021, she came to the Chandigarh Judicial Academy as a faculty, and therefore, as a faculty of Chandigarh Judicial Academy, Madam Harshali, besides looking after many other aspects, looking after this particular domain in particular. Why? Because she is trained into that particular field, and that's the reason. She is the master trainer, one of the 96 across the country. She was nominated in this particular context on cyber crime and investigation, as well as digital evidence, as trained by the E-Committee of the Honorable Supreme Court of India. Nominated by the E-Committee, again to attend the course at the National Police Academy, Hyderabad, also the Indian Institute of Public Administration, New Delhi. She has keen passion in the advancement of technology and to understand as to how the cyber crime is committed, as well as anatomy of cyber investigation. She is accredited with certificates from reputed international organization, EC Council, as certified ethical hacker and computer hacking forensic investigator. Presently, she is pursuing the certificate course on intellectual property from the Indian Institute of Law, New Delhi. I'm so very happy to present to you Madam Harshali Chowdhary, who would be taking this particular session to deal with judicial appreciation of digital evidence. Over to Madam Harshali Chowdhary.
Thank you very much, sir, for your kind words of introduction. And if you, with your permission, I start the last session of the webinar. The topic, ji sir, my screen is visible, I believe. I'm audible?
Yes, ma'am.
Okay, thank you. In today's session, we will try to understand the judicial appreciation of the electronic records so produced before the court during the course of inspection in the evidence. So at the foremost, before we dive into the sea of electronic records, the first questions which comes into the mind is what is the status of the tape records? So in the case of R.N. Malkhani versus State of Maharashtra, it was held that the tape is the primary and direct evidence of what has been said and recorded. The tape records of speeches were documents as defined by Section 3 of the Evidence Act, and they are admissible in evidence subject to the satisfaction of 3 conditions: identification, accuracy, and relevancy. Now, what exactly electronic records are? So now we have to understand that with the advent of Information Technology Act 2000, which was based on the United Nations Commission on International Trade Law, Indian Evidence Act, amongst other acts, was amended to allow the admissibility of the digital evidence. Now with the amendment, Section 3 of Indian Evidence Act was also amended, and it defines documentary evidence as all documents including electronic records produced for the inspection of the court, and such documents are called documentary evidence. Now the terminology electronic records and electronic forms were also assigned the same meaning as assigned to them in the Information Technology Act 2000. So for that, we are required to see the definition of electronic record under Section 2T of the Information Technology Act, which defines the same as data stored, received, and sent in an electronic form. And data has been defined under Section 2O of IT Act, while electronic form is defined under Section 2R of IT Act. So electronic record is nothing, but it is a data plus electronic form. Now, the next question is that what cannot be an electronic record? As already touched by Nishit sir in the morning session, that Section 1, Subsection 4 of the Information Technology Act speaks that nothing in this section shall apply to documents or transactions specified in the first schedule. So on a glance of Schedule 1, it rules out 5 kinds of documents or transactions which do not fall within the Information Technology Act, which are Negotiable Instrument Act other than a check, power of attorney, trust, will, or any contract of sale, of conveyance, or immovable property. Meaning thereby that if a document is falling under any of these conditions, they cannot be taken into consideration as electronic record. Now, how the electronic record is to be proved? So since morning, we have been talking about the genuineness of the electronic record. We received lots of questions as to how to prove that the electronic record received as an evidence is a genuine or not. But the beginning point, the inception of the electronic record is not to determine the genuineness of the electronic record, but as observed by Honorable Supreme Court in the case of Anwar PV versus PK Bashir, that genuineness, veracity, or reliability of the evidence is seen by the court only after the stage of relevancy and admissibility. These are some of the first principles of rule of evidence. Hence, in order to prove the electronic record, the foremost question before the court should be that whether the electronic record is relevant and whether it is admissible in the eyes of law before getting into the question as to whether the electronic record is a genuine, reliable, or some authenticity can be placed upon it. Now, another question that we have is that where the electronic record, which is a document, if it is admitted by a party during the course of evidence, needs to be proved. Answer to that question we will find under Section 58 of Indian Evidence Act, which speaks that the facts admitted need not be proved in any proceeding which the parties or their agents agreed to admit at the hearing, or which before the hearing they agreed to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted by their pleadings. Now, for example, where A relies upon a transaction to have happened with B over an email, an email was admitted to have been received and the contents of the email have also been admitted by B. In that scenario, ordinarily, the said email being the electronic record need not be proved. However, the proviso to Section 58 speaks that even in such scenario, the court may in its discretion require the facts admitted to be proved otherwise than such admissions. Reference can also be made to section 294 CRPC, which speaks with regard to no formal proof of certain documents. Perusal of section 294 CRPC connotes that where prosecution or defense relies upon an electronic record to which the accused or prosecution does not dispute its genuineness, such electronic record may be read in evidence without formal proof. Another question is that whether oral evidence on the contents of the electronic record can be given. Now we can find the answer to this question in section 59 of Evidence Act, and it says that all facts except the contents of documents or electronic records may be proved by oral evidence, meaning thereby that oral evidence cannot be given to prove the contents of the electronic record. So the natural question should come that how the contents of the electronic record may be proved. So now it is more or less settled with the case of Arjun Pandit Rao that the contents may be proved either by the primary or original evidence if produced before the court during the course of evidence, or by way of secondary evidence with certificate under section 65B Evidence Act. The secondary evidence can be in any form, that is computer output by way of printout, compact disc, VCD, pen drive, etc. Another question is that whether provisions of section 63 to section 65 Indian Evidence Act are applicable to prove electronic records. Now, in the case of state of NCT Delhi versus Navjot Sandhu alias Afsan Guru, the famous parliament attack case, the issue on production of electronic record as evidence was considered while considering the printouts of the computerized records of the call pertaining to the cell phone. Honorable Supreme Court held that irrespective of compliance with the requirements of section 65B, which is a provision dealing with admissibility of the electronic records, there is no bar adducing to adduce secondary evidence under the provisions of the Evidence Act, namely under section 63 to section 65. Now it would be worthwhile to mention that section 65A is a specially incorporated section in the Evidence Act, which gives special provisions as to evidence relating to electronic record. Section 65B speaks that the contents of the electronic record may be proved in accordance with provisions of section 65B, and it speaks about the admissibility of the record. Thereafter, in the case of Anwar versus PK Bashir in the year 2014, the judgment of Navjot Sandhu in this respect was overruled, and it was held that section 63 to section 65 have no application in the case of secondary evidence by way of electronic record. The same is wholly governed by section 65A and section 65B Evidence Act. It was also held that the original electronic record is admissible as primary evidence under section 62 Evidence Act, and secondary evidence is admissible only with the certificate under section 65B Evidence Act. If no certificate, the evidence is not admissible. Now, before diving into the certificate under section 65B, we should understand as to what purpose is served by the said certificate. Now, this was also answered by Honorable Supreme Court in the case of Anwar PV, that the certificate ensures the source and authenticity of the electronic record. The electronic records being more susceptible to tampering, alteration, transposition, accession. Hence, without such safeguards, without the certificate under section 65B, the whole trial based on proof of electronic record can lead to the travesty of justice. Now, it would be another question that we require to understand is with regard to the origin of the certificate, as to from where the certificate has actually originated. For that, we have to see that Section 65B has its genesis in Section 5 of the Civil Evidence Act 1968, which is a UK law and now has been repealed under Section 15 subsection 2 of the Civil Evidence Act 1968. So far criminal proceedings are concerned, for the criminal record, Section 69 of the Police and Criminal Evidence Act 1984 UK law comes into picture, which also now has been repealed by Section 60 of the Youth, Justice and Criminal Evidence Act. Now straight away coming to Section 65B. Now what is Section 65B? Section 65B has 5 subsections. First subsection of Section 65B states that any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed to be also a document if the conditions mentioned in the section are satisfied. So for the kind of information that Section 65B is talking about, if 2 conditions, that is in relation to the information and the computer in question which is involved, if these 2 conditions are satisfied, such evidence, such electronic record shall be admissible in any proceeding without further proof of production of document. So now what are those conditions in relation to the computer and in relation to the information has been given under Section 65B subsection 2. Now Section 65B subsection 2 speaks about 4 conditions. If we see this subsection carefully, condition A and condition A and condition C would relate to the condition with regard to the computer in question, and condition B and condition C condition B and condition D would relate to the information in question. So condition A says that the computer should be regularly used to store and process the information for the purpose of any activity regularly carried over that period by a person having lawful control over the use of the computer, and the computer should be properly operated during the relevant period of time. So if these 2 conditions are satisfied, the secondary evidence is admissible without further proof of production. Also with regard to the information, it says that the information contained or derived in electronic record should be regularly fed and derived in ordinary course of activities, and whatever information is being derived, it should come from the information what was being fed. So if these 2 conditions are satisfied, then the secondary evidence is admissible without the further proof of the or the production of the original evidence. Now Section 65B subsection 3 is more kind of a clarificatory in nature, which speaks with regard to the computer which was being used to store the information. So Section 65B subsection 3, it says that and provides that the computer output produced could be data stored or information processed by a combination of computers operating simultaneously during the period, or different computers in succession over the period in question, or even multiple computers operating over that period. Now the reason for incorporation of this subsection, the subsection 3 in Section 65B, was that this provision recognizes that information or data is easily or frequently, for convenience, business or technical reasons, transfer copies recorded or stored in different machines or equipments simultaneously or in succession. The importance and relevancy of succession could arise, and long after it is created, backup or archive are maintained to store specific and important information. In such cases, all computers used for the purpose during the period in question from the beginning till the period when the output is obtained are treated and regarded as the single computer for the purpose of this section. Now, section 65B, subsection 5 is also clarifactory in nature. It provides the relationship between the supply of information vis-a-vis the computer output. It has got 4 subclauses, and clause A speaks that if the information is supplied by means of appropriate equipment with or without human intervention, the computer output can be produced directly. It can be produced either while printing as a result of pre-existing commands or by human intervention. Computer output may also be a result of appropriate equipment attached to the computer. Further, if we see section further section 65B subsection 5, it also explains the term official, which is we will find under section 65B subsection 4 as to who is going to sign the certificate. Now, coming to the question as to what should be the content of the certificate under section 65B, the conditions are laid down under section 65B subsection 4. It means that as held in the case of Anwar PV versus PK Bashir, that where the secondary evidence is produced, the same has to be accompanied with the certificate under section 65B with the contents as applicable laid down under subsection 4 of section 65B. The first certificate should be that it identifies the electronic record containing the statement. The certificate must describe the manner in which the electronic record was produced. The certificate must furnish the particulars of the device involved in the production of that record. The certificate must deal with the applicable conditions mentioned under section 65B subsection 2 of the Evidence Act. The certificate must be signed by a person occupying a responsible official position in relation to the operation of the relevant device or management of the device. The person need only to state in the certificate that the same is to the best of his knowledge and belief. However, later in the case of Arjun Pandit Rao Khotkar, Honorable Supreme Court held that the word and between knowledge and belief be read as or, as knowledge and belief cannot go hand in hand. So the sample of the certificate, for example, for email has been explained in the case of ARK Shipping Company Limited versus GRT Ship Management Private Limited by Bombay High Court in the year 2007. When we will talk about how the different kind of electronic records are to be proved, I will also show you with the samples or formats of the certificate under section 65B, which should be accompanied with the secondary evidence of such electronic record. Now, the foremost question, and we really need the clarity on this point, is as to who will give the certificate. Now, section 106 of Evidence Act speaks with regard to the burden of proving the fact, especially within the knowledge of any person. The burden of proving the fact would be upon him. Section 65B subsection 4 Evidence Act burdens that responsibility to the person having official position in relation to the operation of the device in question or the management of the relevant activities. Further, applying both the provisions, the section 106 and section 65B, the burdens lies on the person who is the burden lies on the person who is responsible in relation to the operation of the device and of whose secondary evidence of electronic record is under consideration for admissibility purpose. Now, where such person fails to discharge the burden, of proving the fact, the court can immediately take the resort of section 114 clause G of Evidence Act that the evidence which could be and is not produced would, if produced, unfavorable to the person who withholds it. Now, it is very important for the court to see that at the time of producing the secondary evidence with the certificate under section 65B, that the concerned person should have the lawful authority to file such certificate, and it should contain the conditions as applicable under section 65B, subsection 4 Evidence Act. We received a question during our registration that suppose a CCTV footage is to be taken from a shop, then the secondary evidence of that CCTV footage, of that electronic record, who will give that that certificate, whether it would be the owner of the shop or the employee of the shop? Well, the answer of that could be found under section 65B subsection 4 only, that the responsible official person, if the responsible official person who is managing the said device or who is in relation to the operation of the said device, if he is the owner of the shop, then he will give the certificate. If he is the employee of the shop, then he will give the certificate. Now, another question is that who will give the certificate where primary evidence is in possession of the complainant, the witness, or at times it so happens when we see in the court that sometimes accused wants to show us some electronic record in the shape of WhatsApp chats or mobile recordings. So in that case, it would be the complainant who would give the certificate with the secondary record. If he's tendering the secondary record in the evidence, it would be the witness, and it would be the accused when the evidence in his favor to file the secondary evidence of the electronic record along with the certificate under section 65B subsection 4 Evidence Act. Another question is that what and who will give the certificate when the electronic record has been recovered during search and seizure. That means if no one owes up to the evidence or it was recovered from the accused. So in that scenario, as we know that the accused cannot be compelled to give the evidence against himself, so the rule of best evidence available would prevail upon, and to my mind, the primary evidence is one of the options that can be produced in the court of law. Another option of producing the secondary evidence along with the certificate under section 65B can be taken into consideration that in case the evidence is recovered during search and seizure and it had been sent to laboratory for analysis, and after the analysis, the expert taking out the print in tangible form gives his certificate as to how he has collected the evidence from the electronic record by feeding it to his computer and producing the output. In that scenario, it would be the expert who would give the certificate under section 65B. These kind of certificate will satisfy the requirement of section 65B of the Indian Evidence Act along with the primary evidence on record if it was recovered from the accused or if no one owns up to that evidence. Now, this analogy I could derive from the case of K. Ramajayam alias Appu versus State of Madras in the year 2016. Further, in the case of Bhupesh versus State of Maharashtra in the year 2018, where the original DVR containing the CCTV footage, thereby recording the murder of the person in the broad daylight in the bar, was brought to the court as primary evidence along with the CD prepared out of the CCTV footage as secondary evidence, Honorable Bombay High Court held that in such scenario, there is no need to file certificate under Section 65B to prove the secondary evidence. So if the original evidence is there along with the secondary evidence, in that scenario, we do not require a certificate under Section 65B. Now, as I have as I've started my session, it is more or less settled that the certificate under Section 65 is a mandatory requirement to make the secondary evidence of the electronic record admissible. But there was an issue that where the primary evidence is not in possession of the party who wants to rely upon that evidence, that electronic record in the court. So in that scenario, who will give the certificate? So in the year 2018, we had Shafi Mohammed versus State of Himachal Pradesh, wherein it was held by Honorable Supreme Court that Section 65A and Section 65B is not a complete code on the subject. Certificate under Section 65B is not required or mandatory when the primary evidence is not in the possession of the party. Such evidence can be proved under Section 63 to Section 65 Evidence Act. Requirement of certificate being procedural can be relaxed by the court wherever interest of justice so justifies. So now the question again cropped up before Honorable Supreme Court as to who will give the certificate when primary evidence is not in possession has now more or less has been settled in the authority of Arjun Pandit Rao Khotkar versus Kailash Bhushan Rao Gorantyal. It's a 3 judges bench authority wherein the law laid down by Honorable Supreme Court in Shafi Mohammed was overruled, and it was held that production of certificate under Section 65B subsection 4 is mandatory in case of secondary evidence where primary evidence is not produced. Oral admission, that is by stepping into the witness box qua such electronic record, cannot be considered as a compliance with such mandatory requirement of production of Section 65B subsection 4 certificate. Further, Honorable Supreme Court also clarified that it can also not be said that electronic record used is a primary evidence under Section 62 of the Indian Evidence Act as held in the case of Anwar PV, but it was held that the same be read without the words under Section 62 of the Evidence Act. Another question is as to whether the oral testimony can take place the compliance of the certificate. So it happens in the courts that at times the prosecution or the investigating agency does not collect the certificate under Section 65B at all from the complainant or from the victim, and when the witness is before the court deposing and the secondary evidence is in question, we do not have the certificate. So can oral testimony of the witness or the complainant from whom the original evidence was seized at the first place and was converted to the secondary evidence, can the oral testimony can be given with regard to the contents of the certificate? The answer to this question was also given by Honorable Supreme Court in the case of Arjun Pandit Rao, wherein it was held that oral evidence in the place of such certificate cannot suffice as Section 65B subsection 4 is admissible only if led in the manner stated and not otherwise. Recently, in the case of Ravinder Singh alias Kaku versus State of Punjab, Honorable Supreme Court reiterated the law that oral testimony as to the compliance of certificate under Section 65B is not the compliance of Section 65B, and such evidence cannot be taken into consideration without the certificate under Section 65B. Now, the question is that whether the requirement under Section 65B subsection 4 can be dispensed with. If yes, under what circumstances? Now, Honorable Supreme Court in Arjun Pandit Rao held that if the original document itself is produced, and this can be done by the owner of the laptop or computer, tablet, or even a mobile phone by stepping into the witness box and proving the device concerned on which the original information is stored is owned or operated by him. However, where the computer happens to be a computer system or computer network and it becomes impossible physically to bring such system or computer network in the court, then the only means to prove that electronic record can be by the certificate under section 65B, under section 65B subsection 1 of Evidence Act. Now, this is a question that we also received, and this was answered by Honorable Supreme Court in Arjun Pandit Rao, that where the party does everything in its power to obtain the requisite certificate from the appropriate authorities, including direction from the court to produce the certificate, and still no such certificate is forthcoming. For example, the authorities concerned willfully refuse on some pretext or the other to give such certificate, the party asking for such certificate can apply the court to the court for such production under the provisions of the Act, CPC, CRPC. Further, once such application is made to the court by the concerned party, then the court orders or directs the requisite certificate to be produced by a person to whom it sends the summons to produce such certificate. The party asking for the certificates has done all that he can possibly do to obtain the requisite certificate. Such application can be moved under section 165 of the Evidence Act, which empowers the judge to order the production of any document or thing in order to discover or obtain proof of relevant fact. Under Order 16 CPC Rules 7, 6 and 10, which also empowers the court to summon and attendance of the witness for production of documents and failure on the part of the witness to comply with the same. Section 1691 also empowers the judge conducting a criminal trial to issue the orders for production of documents, and the punishment for non-compliance is provided under section 349 IPC for the offence where the person refuses to answer or to produce a document, meaning thereby that if the party is unable to produce the certificate under section 65B, as the original evidence was not lying with him, and he moves the application before the court for procuring that said certificate, it is the bounden duty of the court to procure the certificate under the provisions that I have just explained to you. We have received a question from Mandeep Mittal sir that in the family court, if there are CDRs, can the court compel the authorities to produce those CDRs? Answer to that question is yes. Under section 10 of the Family Court Act, the Family Court has got all the powers as that of a civil court, and it can direct the authorities, the concerned service provider, to give the CDRs. So courts have ample power in that respect. Now, what is the stage under which the certificate under section 65B Evidence Act is to be filed? Whether the certificate under section 65B subsection 4 suggests that it must be contemporaneous to the electronic record. Now, answer to that question, in the case of Arjun Pandit Rao Khotkar, it was held that the stage of admitting documentary evidence in the criminal trial is filing of the charge sheet, and the electronic evidence, that is computer output, has to be furnished at the latest before the trial begins. However, depending upon the facts of the case, the court exercising discretion after seeing that the accused is not prejudiced by want of fair trial, may in appropriate cases allows the prosecution to produce such certificate at a later point of time. subject to the balancing of the rights of the parties and preventing serious irreversible prejudice to the accused, so long as the hearing of the trial is not over, the requisite certificate can be directed to be produced by the judge at any stage, so that the information contained in the electronic record can be admitted and relied upon in evidence. Honorable Rajasthan High Court also examined the issue whether a contemporaneous certificate under Section 65B would be required for admissibility of a CD in evidence, to which it was held that there is no requirement for procurement of a certificate under Section 65B of Evidence Act at the time of taking the electronic record, and the same could be procured and submitted later at the time of the production of such document and the evidence. The same issue was also considered in the case of Kundan Singh versus State, Avadut Vaman Kushe versus State of Maharashtra, Arjun Pandit Rao Khotkar, and lately in the case of Sunil Kumar Gulati versus State of Punjab, wherein Honorable Punjab and Haryana High Court also held that the certificate under Section 65B can be produced subsequently in any circumstances. Now, this is an important issue that we will be talking about is with regard to the inadmissibility of the electronic record and the mode of proof. We will also talk about as to whether the accused can waive of his right to the mode of proof. Now, in the case of let's see a scenario where the electronic record is exhibited in the court without the certificate under Section 65B CRPC, and no such objection was taken by the opposite party with regard to the mode of proof. Now, in the case of Sonu alias Amar versus State of Haryana, AIA 2017, CDRs, being the electronic record, were exhibited before the trial court without a certificate as required under Section 65B subsection 4. No objection was taken relating to the mode of proof or method of proof at the time of marking the document as exhibit before the trial court, so much so that no such objection was also taken before the appellate authority. The objection that CDRs were not proved for want of certificate under Section 65B was taken for the first time before Honorable Supreme Court. In that scenario, it was held by Honorable Supreme Court that objection cannot be permitted to be raised at this stage, as the objection relates to the mode or method of proof, admissibility of the document which is inherently admissible. Inadmissible is an issue which can be taken up at the appellate stage because it is a fundamental issue, but the mode or method of proof is procedural. An objection, if not taken at the trial, it cannot be permitted to be taken at the appellate stage. If the objection to the mode of proof are permitted to be taken at the appellate stage by a party, the other party will not have the right, will not have the opportunity to rectify the defect. Now, another scenario is that what if defective certificate is filed before the court and the secondary evidence of the electronic record is exhibited without any such objection as to mode of proof? Would such evidence be read? In the first situation, we understood that if there is no certificate. Now, the second scenario is if there is a defective certificate. Well, these situations do arise in the court where defective certificates are filed and the electronic records are exhibited without any objection. In that scenario, it is the bounden duty of the court to be vigilant when such certificate is tendered along with the secondary evidence to cure the defect at the first place. However, in case the defective certificate is taken with the secondary evidence and is made admissible without objection, the accused cannot take the benefit of the defect in the certificate and challenge the admissibility of the secondary evidence on the mode of proof. However, now it is settled in the case of Arjun Pandit Rao Khotkar that the certificate can be filed at any stage of the trial and is not contemporaneous with the evidence. So if it has come to the notice of the prosecution or the court with regard to the defective certificate, then the appropriate application can be moved to cure the defect. Now, in the case of Sonu alias Amar versus State of Haryana, one of the questions decided by Honorable Supreme Court was with regard to the fact, can the accused waive of his right to mode of proof? Honorable Supreme Court referred to Section 294 CRPC and observed that it provides a procedure for filing documents in a court by the prosecution or the accused. The documents have to be included in the list and the other side shall be given an opportunity to admit or deny the genuineness of such document. In case the genuineness is not disputed, such documents shall be read in evidence without formal proof in accordance with the Evidence Act. Section 294 subsection 1 of the CRPC enables the accused also to waive his right of mode of proof by admitting or raising no dispute as to the genuineness when called upon to do so under subsection 1. Subsection 3 enables the court to read it in evidence without requiring the same to be proved in accordance with the Evidence Act. The mode of proof of it is liable to be waived off as that of any other document. It was also held in this case that the documents being primary or secondary or substantive or corroborative is not relevant for attracting Section 294 CRPC. When the genuineness is not disputed, the document is, even if it is electronic record, it is admitted, it is exhibited and it is admitted by the party. It can be taken into consideration by the court. Now, another vital question is with regard to the compliance of Section 207 CRPC with regard to the electronic record. Now, this question was posed by Honorable Delhi High Court in the case of Dharambir versus Central Bureau of Investigation, that whether the accused was entitled to the mirror image of the original electronic record, that is the original evidence, which were 4 hard disks containing the telephonic conversations of the accused persons with other persons, along with other conversations unrelated to the case. Although the accused persons were supplied with the CDs prepared from the original hard disk, along with a certificate under Section 65B containing the relevant intercepted telephonic conversations, which was subject matter of the case on which the prosecution was relying upon. It was held by Honorable Delhi High Court that the certification in terms of Section 65B subsection 4 Evidence Act, along with the secondary evidence, it does not obviate the statutory requirement of Section 207 subsection 5 of providing the accused access to the original recording of the relevant intercepted telephonic conversation as a relied upon document. However, only those portions of the hard disk that relate to the files would be the documents proposed to be relied upon by the prosecution in terms of Section 207, read with Section 173 subsection 5 subsection A CRPC. Those files would be documents both as regards the file containing the actual conversation so recorded, as well as constituting a record of any changes that such file may have been subject to thereafter. Therefore, only those files, only those documents which were relevant for the accused for the purpose of the case, the accused would have the right of inspection of the hard disk, since making mirror image copies of the entire hard disk is not called for. Recently, in the case of P. Gopalakrishnan versus State of Kerala in the year 2020, it was held by Honorable Supreme Court that the contents of the memory card on the or pen drive in which video footage or clipping is contained, being an electronic record, must be regarded as a document. If prosecution proposes to rely on it against the accused, ordinarily accused must be given a cloned copy as per the mandate of Section 207 to enable him or her to present the effective defense during the trial. However, Further, it was held that in cases involving issues such as privacy of the complainant or witness or her identity, it is imperative on the part of the court to issue suitable directions to balance the interest of both sides, that is, right to fair trial of accused and right to privacy of the victim. Court in such cases, instead of giving clone copy of the contents of the memory card or pen drive to accused, may be justified in providing only inspection thereof to the accused and his or her lawyer or expert for presenting effective defense. Court may further enable the accused to reassure himself about the genuineness and the credibility of the contents of the memory card or pen drive from an independent agency like CFSL so as to effectively defend himself during the trial. Now, this judgment of P. Gopal Krishnan is required to be read with the judgment of Honorable Supreme Court in the case of Nipun Saxena versus Union of India, that the identity of the victim in the cases where the privacy is involved should not be disclosed at any point of time by the court or by the investigating agency during the investigation. However, how the copy or the mirror image or the clone copy of the electric record is to be given to the accused under section 207 CRPC has been explained by Honorable Supreme Court in the judgment of Tarun Tyagi versus CBI, in which it was held that the accused has a right to get the copies of the electronic record under section 207. In the said case, certain directions were also issued with regard to the manner in which the cloned copies were to be supplied to the accused by the court. Before supplying the copies, contents of that shall be recorded in the court in presence of the complainant as well as the appellant, and both of them shall attest the veracity thereof by putting their signatures so that there is no dispute about the contents later, thereby removing the possibility of tampering. The accused was also directed not to make use of the source code, as the source code was involved in that case contained in the CD, or misuse the same in any manner. Now, in the morning session, we were speaking about the hash feature. So the court may also calculate and compare the hash value of by using freely available software like Calculate My Hash or HashCalc of cloned CD with the original primary evidence before supplying the copy of the cloned CD to the accused and make a relevant reference of the same in the order sheet. There are many variants of hash. Most preferred one are SHA-1 and MD5. Another issue that we face in the code is with regard to the superdari of the electronic records. So now the question is that can the original electronic records, the original electronic equipments containing the electronic record be given in superdari under section 451 CRPC? Now, in the case of Lenovo Private Limited versus State, the question involved was whether 950 numbers of Lenovo desktops, 291 numbers of Lenovo laptop computers and 293 number of Lenovo laptop computers which were released on superdari can be ordered to be sold off by virtue of section 451 read with section 457 CRPC. All these electronic equipments were involved for the commission of offence under section 406 IPC. Honorable Madras High Court, taking note of the law laid down by Honorable Supreme Court in the case of Sundar Bhai Ambalal Desai versus State of Gujarat, granted the permission to the owner to sell off the electronic record with the directions that the photography of the case properties would be taken on which the magistrate will obtain the signature of the accused. In case the accused makes any dispute or contention as regards to the case property, the same shall be endorsed in the photographs and signatures shall be obtained. Thereafter, the magistrate shall grant the permission to sell the case property. Honorable Madras High Court observed that if computers or other electronic items are kept as it is, naturally, they will lose their utility value as such properties are subject to speedy and natural decay. In the case of Charan Singh versus Sanjay Goyal in the year 2015, Honorable Madhya Pradesh High Court, the issue involved was whether sonography machine can be released on Superdari considering the nature of the machine being an electronic equipment. It was held that machine is an electronic equipment which requires continuous maintenance. If kept locked and unattended, the value of machine may deteriorate. If the magistrate is of the view that some evidence is to be extracted from the memory chip of the machine, same can be done immediately. The printout may be taken with the help of the experts and thereafter the machine may be handed over to the complainant. Where the electronic instrument is stolen or is not used for the commission of the crime, they may be released on Superdari under section 451 CRPC, read with section 457 CRPC on the discretion of the magistrate. Same analogy can be applied where the electronic equipment containing the electronic record is seized from the complainant or the victim. Once the secondary evidence is prepared from the original record and it is duly supported by a certificate under Section 65B Evidence Act with a chain of custody complete from the collection to the preservation to the production before the court with the subsequent orders of sending it to the FSL lab and receiving it back from the FSL lab if so required, considering the perishable nature of the electronic record, original electronic record, the same may be returned under section 451 CRPC, read with section 457 CRPC to the complainant or victim or witness as the case may. However, some caution is to be applied at the time of returning the original equipment electronic record containing recovered from the accused from the hands of the accused, depending upon the case to case. But again, if the original electronic record equipment containing the electronic record is no more forensically required to or the same is of no relevancy pertaining to the matter involved, the same may also be returned to the accused. The sole discretion lies with the court, which is also subject to the provisions of the special law if applicable. Now, the next question comes is with regard to the final disposal of the CD, computer, mobiles used in crime if they are not claimed by either of the parties and they are still lying in Malkhana. Now the same can be ordered to be disposed of at conclusion of trial under section 452 CRPC. Central government has specifically made rules for the disposal of e-waste management known as e-waste management rules. It authorizes registered collectors of the e-waste to collect and dispose of the e-waste. The court may pass appropriate directions under section 452 CRPC to the in charge Malkhana of the court to dispose of the seized electronic record by delivery to the registered collectors. Now coming to the kind of electronic records that are produced before the court in the course of a criminal trial or in any case or even in cybercrime. So they can be in the shape of email, mobile, hard disk, digital photographs, memory cards, SMS, MMS, WhatsApp messages, compact disk, pen drive, CCTV footage, video film, call detail records and bank statements. How these records are to be proved before the court and what is the probative value with regard to these records are the next questions that we are going to consider. Now first we will take emails. So now it would be very difficult for the court during the course of a trial or even in the civil case that every time for the purpose of hearing the prosecution or the complainant or the parties on the civil side claiming emails as one of the evidence to show the original evidence would open the original email by putting the username and the password before the court and show the original evidence. It would also be very difficult for the court at the time of deciding the case as neither the original email would be there and nor the printout of the email would be available for the court. The only evidence that the court will have would be the ocular evidence. So the only mode of proving the email is by way of printout. Now, in order to understand the email, there is an entire field of email forensics called email forensics. It is dedicated, which studies the source and content of the electronic email as evidence. In order to understand the email, it is required that the said email identifies the IP address of the sender, date and time of the email, as well as the message or content. So for the hands-on experience, I had opened an email for the audience to see. So this was one email that I have received. So in order to see the original of this email, all I have to go to these three dots, and here I will have show original. This is a Gmail account and I will have this show original. This would be the header of the email. So with the printout of the email, we require the header of the email to prove the genuineness of the email along with the certificate under Section 65B Evidence Act. As it was mentioned in the previous sessions, that it is very easy now to have those kind of emails which are only there for 15 minutes and then they vanish in thin air. So how to see if the email is genuine or not? What I'm going to do is I'm going to copy the header of this email, copy to the clipboard, and I typed email header analyzer on my Google, and the first toolbox that I got to analyze the email is mxtoolbox.com. I click here. And I am going to paste that header here. So then I'll click analyze header. So now if I see the header is being analyzed, it is going to give me all kind of information as to what has been found in this header, that to whom the email was delivered to, who has sent the email, from where the email has come, what is the date, what is the message, special message ID, what the email has got. It has got an image and the content type. It will also give me the entire path. The entire path would be given to me as to where my email has traveled to reach, or the email that I have received, the entire path that that email has traveled to reach the destination. So this is very important for us to know about the email header, to understand or to rely upon the genuineness of the email that has been filed before us in the court, with email as being one of the evidence. Now, let's go to the probative value of what is the probative. Before that, yes, when it is a Gmail or Hotmail, if the email is from the Gmail or Hotmail, the printout of the email can be proved by presenting the header of the email along with certificate under Section 65B. If the email is from the server of a company, then again it can be proved from the header, the printout and the certificate under Section 65B. Standalone applications like Outlook, again the principle is same, the printout, header and the certificate under Section 65B. Now, what is the probative value of the emails? Now, Section 88A of the Indian Evidence Act provides for the rebuttable presumption as to the electronic messages as to the email forwarded by the originator to the address of the receiver corresponds with the message as fed into his computer for transmission. So the presumption is only with respect to the message, that so long the message was in between the sender and the receiver, it was the same message that was fed into the computer, that was sent, and it was the same message that was received. But this presumption is rebuttable, and further, the presumption is only with regard to the message and is not with regard to the genuineness. To analyze, to understand the genuineness of the email, the header of the email is the only way, especially now since we are also having the phishing attacks, and as in the morning session we have also come to know about man in the middle attack, in which a person, a hacker, if he's sitting between the correspondence happening over the email between two persons, he can hijack the active session, download the contents, manipulate them, and then send the same to the receiver. So yes, email header is the only genuine way to understand if the email is the right email that has been transacted between the parties. The reliance upon the email was heavily made in the case of Abdul Rahman Kunji versus State of West Bengal. And if I may show you the certificate under section 65B, which is required for the email printout, if I can. This is the kind of a certificate that we are looking for the email for the under section 65B, when the web email printout from public internet service provider, that is Gmail or Yahoo, is given. So here he will give the particulars, the electronic records, web email description. He will also tell the computer from where he is giving the printout, and he will then give fulfill all these conditions, and then he will sign the certificate, and this would be a complete certificate along with the printout and the email header to complete the chain of the evidence. I'll be sharing this format with you eventually. With regard to the email, when it is given via client like Outlook, this is the kind of a certificate that we should be looking for. The certificate under section 65B from Microsoft Outlook or Outlook Express. Again, he will give the description of the electronic record, the description of the email, the computer from where the email is being downloaded or printed, and all other conditions as required under section 65B, subsection 4 of the Indian Evidence Act. Now, coming back to my presentation, how would the contents of the website are to be proved? Like, for example, the Facebook or the Twitter or any other Instagram that the website we are using, how the contents are to be proved. So the contents of the website may be proved by the printout of the contents or the printout of the screenshots of the website. Although the screenshots are the weakest kind of secondary evidence, instead of the screenshot, if the contents of the website are required to be proved, they can be proved by way of secondary evidence by opening the website on the browser and getting it screen recorded. Screen recorder, it is a utility available on the desktop, or it can be downloaded. The video then can be transferred to a pen drive or CD, as the case may be, and it can be filed before the court along with the certificate under section 65B. There are also free tools available which can download the entire website in the offline mode. The same again be copied in the pen drive or CD along with the certificate under section 65B, along with the providing of the details of the software used. The format of the certificate under section 65B has been discussed and has been given by Honorable Delhi High Court in the case of Toyota Jidosha Kabushiki Kesha versus Deepak Mangal and others. In the case of Google India Private Limited and others versus Visakha, emails were the contents of the websites were heavily relied upon, which were defamatory in nature, and accordingly damages were awarded to the plaintiff. Now, another question that we often have is with regard to the WhatsApp messages, SMS, MMS, how these electronic records are to be proved. Now, the best way to prove the WhatsApp message is through secondary evidence. It is to export the entire WhatsApp message of the contact on which the evidence is required to be given, and the same be sent to the email or saved as a file which can be copied in the pen drive later on. Email containing the WhatsApp message as attachment is to be proved like the email as discussed along with the certificate under Section 65B Evidence Act with regard to the exporting of the contents from the WhatsApp to email and the printout of the email with the exported file along with the header of the email and the certificate under Section 65 Evidence Act. The said secondary evidence of the WhatsApp contacts be also supported with a list of contacts available on the WhatsApp to connect the same with the perpetrator of the crime. As usual, printout of the screenshots of the WhatsApp is a weak secondary evidence. Nevertheless, the secondary evidence can be proved along with the certificate under Section 65P. SMS can be proved by the original mobile phone containing the SMS or extracted copies or screenshots of the SMS along with the certificate under Section 65 Evidence Act. Now, whether the WhatsApp chats can be used in the court. No, this was okay. Can be used in the courts was there in the in Ambalal Sarabhai Enterprise versus KS Infraspace, wherein it was held that yes, they can be used as evidence provided they are produced in the evidence by completing all the formalities as required by the law. Now, whether the forward messages can be treated as evidence in the case of National Lawyer Campaign for Judicial Transparency and Reforms, it was held by Honorable High Court on a petition filed by the petitioners on the basis of the viral post with regard to the alleged suicide note of their chief minister on WhatsApp seeking direction to register the FIR, held that the petitioners were not privy to any information except on an alleged WhatsApp circulated post. They have not stated as to that how in any manner they have tried to ascertain as to whether the allegations contained in the forwarded message is true or not. Nothing has been pleaded or shown as to how they could even form the reasonable belief that the post allegedly circulated on WhatsApp was correct or not, and how they have received the WhatsApp post as the known sender was also not there. Therefore, in such scenario, forwarded message cannot be treated as an evidence. However, the case with regard to the forwarded messages on WhatsApp would be different footing when suppose a child pornography clip is being circulated on the WhatsApp as viral post, which is an announcence to the informant who is not even a privy to the matter, thereby attracting the penal provisions under Section IT and under POCSO Act. As in such cases, WhatsApp can be treated as evidence. Another question is that whether courts can form the prima facie opinion on the basis of WhatsApp messages to decide the question of bail. So in the case of Chirag Deepak Bhai Sulekha, Honorable Gujarat High Court considered the WhatsApp messages exchanged between the accused and the prosecutrix and granted bail to the accused. However, in the case of Rakesh Kumar Singla versus Union of India, Honorable Punjab and Haryana High Court held that without a certification under Section 65B, along with WhatsApp messages, such messages cannot be taken into consideration for granting the bail. How the evidence from the smartphone, how the contents of the electronic record from the smartphone can be proved before the court of law. Smartphones are nothing but they are the computer system with inbuilt memory is hard disk and SD is an external storage. Recording in the mobile or the photographs or the contents can be proved by the original mobile containing the record or the secondary evidence with a certificate under Section 65B. Where the storage of the electronic record is made on the cloud, as now it happens in most of the cases, iCloud or Google Drive, the same can be proved only by way of secondary certificate, a secondary evidence by way of certificate under Section 65B. The standard operating procedure for correcting the evidence and preserving the same have been laid down in the case of Vijesh versus State of Kerala in the year 2018 by Honorable Kerala High Court. However, the issue may arise with regard to the secondary evidence of the recordings made on the call recording apps which are prevalent in the Android phones. Even the contents of the voice call is transferred to the pen drive or CD as secondary evidence. There is a possibility that for want of proprietary software or necessary drives required for those recordings to be played, if those recordings are not played on VLC or window media player, in that scenario, the only option with the person who wants to rely upon the recordings made through WhatsApp, through call recording apps, is by producing the original mobile phone. So what is the certificate format for the mobile phone is also here. I'll draw your attention to that. This is the 65B certificate for the mobile phone. Again, he has to give the description of the electronic record, again the server or the computer, the mobile, the model, the serial number, the software from where which was being relied upon, the OS of the mobile, if it has got a memory card, yes or no, and all other conditions as stated in this sample. So this is the kind of a certificate that we are looking for when we have the mobile recordings, when we have the evidence from the mobile in the shape of secondary evidence before the court as the secondary evidence. Now coming to the hard disk, the contents of the computer on the hard disk, how these contents are to be proved. Now seizure of the hard disk and its preservation is cumbersome and a very troublesome for investigating officer. Nevertheless, in serious crimes, original hard disk is the best evidence to prove the contents. However, considering the cost of the hard disk, for example, CCTV footage or CCTV used if installed in a huge area cost crores of rupees. So it would be a sheer loss on the complainant or victim or third party in that scenario. Hence, the contents of the hard disk can be copied on an external media or printed and along with the certificate under section 65B, where the certificate and where the original hard disk is produced before the court along with the secondary evidence. In that scenario, the certificate under section 65B is not required. In the case of Kishan Tripathi alias Kishan Painter, original hard disk was containing the CCTV footage with regard to the murder of the person was produced before before Delhi and Honorable Delhi High Court upheld the conviction of the accused. Photographs or video films, how the contents of the photographs or video films are to be proved. So the digital photographs or video films, if taken from the camera or mobile phone, in the case of camera, if they are stored in memory card, in case of mobile phone, if there is an external memory, then they will be saved in the SD card. So where the internal memory of the camera or mobile is used to store the image, original device is the primary evidence. In case of printouts, CDs or pen drive, a certificate in terms of section 65B is required. Whenever a video film is produced in evidence, the court must play it and record the relevant contents in deposition of the witnesses. If the video film is collected during the course of investigation, then it should be played in the testimony of the investigating officer, and if it is produced by the party himself, then it will be played and recorded in the testimony of the party. Pen drive or the compact disc, how they will be proved. So CDs, they are primarily used for making the copy of the records. So whenever the contents of the electronic record is to be proved by a CD or a pen drive, it is mandatory to support it with a certificate under section 65B Evidence Act. However, as it was in the case of Anwar PV versus PK Bashir, that the contents of the CD in which the objectionable speeches and songs were recorded were in dispute and were the primary evidence and were never produced before the court. So where the contents of the CDs are itself facts and issue, in that case, original CD is required. The secondary evidence will not, fulfill the purpose. Now, this is the most important fact, most important electronic record that we generally have, and we have received number of questions as to how the CCTV footage is to be proved, what is the probative value of the CCTV footage, what is to be seen when the CCTV footage is there. So the importance of CCTV footage as the best evidence available was emphasized in the case of Tommaso Bruno versus State of UP in the year 2015, where failure on the part of the investigating agency to seize the best evidence available resulted in the acquittal. This question with regard to the appreciation as to how to appreciate the CCTV footage as evidence had come and considered beautifully by Honorable Delhi High Court in the case of Kishan Tripathi alias Kishan Painter versus State. In the said case, I would specifically draw the attention of the esteemed audience to para number 14 of the judgment, where Honorable High Court discussed as to how the CCTV footage is captured in the cameras. In nutshell, it was observed that CCTV footage was captured by the camera and can be stored in the computer when files are created with serial number, date, time and identification marks. In identification marks and details are self-generated and recorded as a result of pre-existing software commands. Capture of visual image on the hard disk is automatic in the sense that the video images get stored and recorded suo moto when the CCTV camera is on and is properly connected with the hard disk installed with the computer. Such primary or direct evidence would enjoy a unique position for anyone who watches the said evidence would be directly viewing the primary evidence. It was further observed by Honorable Delhi High Court that when we witness the CCTV footage, we are in the same position as that of a witness who had seen the occurrence through crime, though crime had not occurred at that time when the recording was played, but earlier. Honorable Delhi High Court has gone to the extent of comparing the CCTV footage with the time machine. It held that the court itself has seen the CCTV footage and has traveled back in time to the time when the occurrence took place and thereby has seen the occurrence in the same position as that of a witness who would have seen the occurrence if he was present. There cannot be a more direct evidence. The video recording which captures the occurrence would be per se mostly discernible, reliable and compellingly conclusive evidence unless its authenticity and genuineness is in question. Now, in para number 16 of the judgment, Honorable Delhi High Court also discussed the ruling out of any possibility of manipulation, tampering or fabrication. It held that the hard disk of CCTV footage must pass the integrity test. It is a twofold test: system integrity and record integrity. System integrity is satisfied by ocular testimonies of the witnesses, and it was held that the system was working contemporaneously and storing the data. On record integrity, it was found that the record remained unchanged. It was although found a lapse on the part of the investigating agency and the prosecution. However, in the opinion of the court, the procedural lapse could not unsettle and nullify the authenticity of the CCTV footage, as there was not a single suggestion or evidence that the accused at any time under compulsion or force was asked to enact the entire crime at the place of occurrence. Further, the court held that the internal evidence had established its genuineness of the CCTV footage. In the case of K. Ramajayam Appu versus State of Madras, is in another authority by Honorable Madras High Court, wherein the judicial appreciation of CCTV footage was made to convict the accused when original DVR was seized and produced before the court. So if I may show you the certificate, the sample of the certificate under section 65B for the purpose of CCTV footage, it should look like something like this. Again, electronic record, description of the document to be proved, CCTV footage, the DVR, the make of the DVR, model, serial number, software, what kind of software was used, and the certificate of the responsible of the official who was responsible for the operation or the management of the device at that point of time. So this is the certificate for the CCTV footage if it is being produced as electronic record in the shape of secondary evidence. Now let's see another electronic record, and that is CDR, call detail record. With the previous sessions, we have discussed a lot about the call detail records. We know that CDR are nothing but they are the digital stamps of the mobile phone, thereby showing the calling party, called party, the starting time of the call, the date of the call, duration, identification of the telephonic exchange or equipment writing the record, unique sequence number identifying the record. And also if the record is voice or it is an SMS or if any fault was found. So Kundan Singh versus State of Delhi. It's para number 28 to para number 38. It appreciated the contents of CDR and it also gave us a guideline as to how the CDRs are to be appreciated by the court at the time of considering the CDRs of the mobile. The nodal officer in that case appeared and explained the entire procedure as to how the CDR was collected from the server of the cellular provider on the request of the law enforcement agency. He also explained the entire procedure as to how the cell towers from where the calls were connected were identified on the CDR. Now the CDR can be proved by printout of the original CDR with the certification under section 65B. Chain of custody is also required to be proved with a certification under section 65B from the service provider or the nodal officer if the printouts were made at the police station, then a separate certificate under section 65B is required to be given by that concerned police officer with regard to this the CDR. So here I would like to draw your attention as to what should be the contents of the CDR, what should be the contents of the certificate under section 65B, what is the sample certificate, what is the sample of certificate under section 65B. For that I'll take your attention to this. So if we see this, if I have to read this entire form because then I will compare as to what kind of certificates under section 65B are being filed before us in the court. So it says that this is to certify that I am, so let's say XYZ occupying the position of the nodal officer, let's say Airtel in the company. The electronic record is the CDR for the period itna. Server, what is the make, model, serial number, software use, operating system, and what is the database. He further gives out the conditions that I certify the aforesaid electronic record generated from the above server, that the electronic record are generated automatically through the data captured in the computer network of base transceiver stations and mobile service switching centers, and finally stored in the server in the ordinary course of business activities of the company. During the period, which is the relevant period, the above mentioned servers were operating properly and there has been no such operational problem so as to affect the accuracy of the electronic record. During this period, the server has been kept in protected environment and the software have built-in security mechanism, that is password protected access control antivirus. The electronic record generated from the above server has been derived from the information fed into them and is a true extract of the data in the aforesaid server. The above said server are in working condition till today, that is when the output was taken from the aforesaid server through my computer, which is connected to the server in the computer network of the company. I am personally involved into the transaction and or generation of the aforesaid electronic record. I'm computer literate and having qualification in IT. The above stated matter is true to the best of my knowledge or belief. Signature, name and designation of the certifying officer. So this is the kind of the certificate under section 65B that we should be expecting. But what certificate has been filed before me in one of the cases was something like this. This was a certificate from the Vodafone company. It only says that certified that CDR of mobile or IMEI number has been produced from the computer system using printer and its contents are true production of the original to the best of my knowledge and belief. Further certified that the conditions as laid down in certificate, the printouts are supplied by us in respect of the aforesaid mobile number is the records lawfully maintained by us in our system during our ordinary course of providing the cellular mobile telephony service during the period mentioned above. The printouts are the retrieval of the records from the information registered in our system in our ordinary course of providing the cellular mobile telephony services, which was operational at the relevant period. The printouts of the calls made incoming and outgoing through the cellular number are supplied by means of auto system generated electronic equipment. The printouts are true production of original retrieved from the electronic system, which is in lawful control of the company and password protected. And if we see the below, there is only a stamp, there is no signature, and the stamp is of the nodal officer in of Haryana service area. What is the name of the nodal officer? What is the designation? If he is the lawful authority, we do not have any of those particulars on the certificate. Now, if we see carefully, he has given this certificate under section 65B, subsection 4, subsection C of the Indian Evidence Act. So now if I open section 65B, subsection 4, so if I see there and I had opened it for you, it says dealing with any of the matters to which the conditions mentioned in subsection 2 relate. So we have seen that what kind of information is required in subsection 2. It is with relating to the information and the computer. So these conditions were these conditions which were written on that certificate, and they were the cut copy paste of those conditions on that certificate. To my mind, it was a defective certificate, as in the case of Anwar PV Bashir, the conditions which are required to be given, what kind of contents of the certificate should be there, has been clearly explained by Honorable Supreme Court. So if we take those kind of certificates in the court to prove the CDR, these are defective certificates, because merely with the certificate we cannot identify the electronic record, we cannot identify with any other detail which relates to the information and the computer in question which was being used. Now, in the case of Gajraj versus State of Delhi, it was the authority wherein Honorable Supreme Court observed the importance of IMEI number and held that IMEI number of the handset on which the accused was making calls by using a mobile phone registered in his name, being the conclusive evidence, cannot be looked over on the basis of minor discrepancies. Another beautiful case with regard to appreciating the contents of the CDR is Ram Mandal, Uttam Mandal, Ujjal Mandal versus State 2016 by Honorable Madras High Court. So in this case, one of the arguments raised by Learned Defense Counsel was that it could not be proved that the accused was using the cellular phone of the deceased after killing her, as the IMEI number of the alleged phone did not show that earlier she was using the handset of her number, which now the accused was allegedly using. So now, in order to connect the SIM number which was earlier being used by the deceased on the handset, Honorable High Court invoked the powers under section 311 CRPC and 391 CRPC and sought the additional evidence with an expert. So whatever in the previous session, Gurcharan sir had told you that there will only be 14 numbers and 15th number will never be given by the service provider and it will always be 0. And he had also shown the entire mechanism as to how the 15th number is to be given. It is based on an algorithm called Luhn algorithm. By applying the Luhn algorithm, which is given in detail in this case of Ram Mandal, that how the 15th number can be calculated, and that's how it was connected, that the phone which was now the accused was using was the same phone which was earlier lying with the deceased who the accused had murdered. So for CDRs also we require a certificate under section 65B. So far the SDR or application form of the customer is concerned. Now this is another vital question that we have come across, is whether we require a certificate under section 65B where the FIRs are concerned, or where the challans are concerned, or where the digital copy of the revenue record is concerned. So now, in order to admit the FIR in evidence, section 154 CRPC requires that every information relating to the commission of the cognizable offence, if given orally to an officer in charge of a police station, shall be reduced in writing by him and or under his direction and be read over to the informant, and every such information, whether given in writing or reduced in writing, shall be signed by the person giving it. So the FIR is complete only if the information is reduced in writing and if it is signed by the informant. So meaning thereby that even if the content of the FIR are typed or fed in the computer in CCTNS software, and the moment the printout comes out and is signed by the informant, it loses its characteristic of electronic record and is a document in the common parlance. In that scenario, certificate under section 65B is not required to be filed to admit as an evidence in case the FIR, the printed form of the FIR is signed by the informant. Challan is not a piece of evidence. It is only an opinion of the investigating agency on the completion of the investigation. Hence, the printout of the same also does not require the certificate under section 65B. Even the certified copies of the digital copies of the judgments and the orders printed as computer output or the digital revenue records, they should, for them also, certificate under section 65B is not required for admitting them as evidence, as they are public documents under section 76 of Indian Evidence Act. Now, coming to the bank statements that we often have in our courts. So now the question is that whether a certificate under section 65B is required for bank statements. Now we often have this statement that this is a computer generated statement and does not require signature. If we find this kind of a line on a bank statement, that document cannot be admitted, is not a valid document to be admitted as an evidence before the court as secondary evidence. We do not require a certificate under section 65B Evidence Act for proving the bank records, but the bank records are to be proved by 3 separate certificates by the person in charge of the computer system in view of section 2 subsection 8 and section 2A of the Banker Book Evidence Act 1891. We received a question that whether the printed memo of return of check requires a certificate under section 65B. For that, I would like to draw the attention to section 146 of NI Act, which says that the court shall, in respect of every proceeding under this chapter on production of the bank slip or memo having thereon the official mark denoting that the check has been dishonored presume the fact that the fact of dishonor of check until and unless such fact is proved. Hence, no certificate under section 65B is required to prove the memo of the check return. Now we have spoken about the relevancy, we have mainly spoken about the admissibility. We have also seen as to what kind of evidence is to be filed, in what shape to be admitted as secondary evidence, and what would be the sample of the certificate under section 65B. However, we are still under some perception that it is the genuineness of a document which is required to be seen before admitting the document, because as it has been told to us in the previous sessions that it is nowadays a trend of manipulating or tampering with the electronic record. So how the genuineness is to be looked into, and what criteria is to be followed for the genuineness of the document. For that, I will first take your attention to Anwar PV versus PK Bashir, wherein Honorable Supreme Court had held that relevancy and admissibility of the electronic record is to be seen. Now, Section 22A of the Indian Evidence Act also comes into play, where the genuineness of the electronic record, secondary or primary as the case may be, is to be taken into consideration. That where oral admissions are made as to the contents of the electronic record, they become relevant, especially when the genuineness of the electronic record is in question. Hence, as held in the case of Kundan Singh versus State of Delhi, genuineness and reliability of the electronic record after the admissibility of the electronic record is of consequence. Now, in the case of Kundan Singh versus Delhi, it was observed by Honorable High Court that information memorized or business records maintained in the common course of events are not treated as hearsay, even if the maker lacks personal knowledge of facts or events. The documents should be prepared in normal course of business, must have been at or near the time of events, records, and should have been made in the normal course of business activities or events. Section 65B, subsection 4, postulates that the certificate should be given by a person occupying a responsible official position in relation to the operation at the relevant device or management of the relevant activities. If the set conditions are satisfied, it promotes and establishes the trustworthiness. In such cases, presumption of act regarding genuineness and authenticity of the content can be invoked at the discretion of the court under section 114 of Indian Evidence Act. It further held that when a certification under section 65B authenticates the computer output, it will only show and establish that the computer output is a paper printout or a media copy and a copy of the computer from which the output was obtained. The court still has to rule out, when challenged or otherwise, the possibility of tampering, interpolation or changes from the date the record was first stored or created in the computer till the computer output is obtained. The courts must rule out that the records have not been tampered and read the data or information as it originally existed. These are the aspects which are not codified, as probative value is to be examined on the case-to-case basis, keeping in mind the relevant facts. Now, in the case of Anwar PV versus PK Bashir, Honorable Supreme Court held that only if the electronic record is duly produced in terms of section 65B of the Evidence Act would the question arise of genuineness, and in that scenario resort can be made to section 45A of the Indian Evidence Act, which seeks with regard to the opinion of the examiner of the electronic evidence. Now, as we have been told in the morning session that under section 79A IT Act, the central government has notified 10 forensic labs as examiner of electronic evidence. So if the secondary evidence is produced before the court with the certificate under section 65B as an evidence, then the presumption under section 114 Evidence Act is attracted, and in case the opposite party is aggrieved that the document is not genuine, then he can always show that the document or the secondary evidence is not genuine, it is tampered, it is interpolated, or if the court is also of the view that it is interpolated, it is not genuine, then the court can take the resort of section 45A and section 79A of IT Act. Now, in the case of K. Ramajayam alias Appu, Honorable Madras High Court observed that the defense will always complain of manipulation, but the courts can reject fanciful objections bearing in the mind the principle underlying in section 114 of the Indian Evidence Act with regard to the rebuttable presumption of the record. Now, there is no presumption that the electronic record is prone to be tampering. Human evidence is easy to be tampered as compared to the electronic record. We may never find if the human evidence is false, but if we apply the Locard principle, that we can always find that the electronic record, if it is lying, that it is lying. Now, for the criminal cases, the proof is beyond reasonable doubt, but not beyond every possible doubt. All reasonable doubts must flow from the facts of the case. Now, in the corridors of the court or inside the courtrooms, we have often heard the arguments that from one side of the party, or maybe from the defense or from the accused side, that despite the secondary evidence duly exhibited and admitted in the court, the complainant or the victim or the prosecution is asked to produce the original document, original primary evidence. Now, for that, the court should always keep in mind the opening line of section 65B, subsection 1, which gives out that non-obstante clause, that is notwithstanding anything contained in this act, if the conditions relating to the computer in question and information in question as laid down under subsection 2 of section 65B satisfied, and if the information contained in the original record, copied or printed in another mode, the same shall be admissible in any proceeding without further proof of production of the original as evidence of any contents of the original or of any fact stated therein of which the direct evidence would be admissible. Hence, when this question arises before the court with regard to the production of the original record in the presence of the secondary evidence, the answer can always be found under section 65B, subsection 1, and the court can always ask the reason for calling the original record. Another objection that may be raised is with regard to section 4 and section 7 of the IT Act, which provides for legal recognition of electronic record and retention of electronic record. It may be argued by the defense counsel that in terms of both the sections, it is required that original or primary evidence should be accessible for subsequent reference. It should be in electronic form. However, if we read section 4 and section 7, it provides that it should be the requirement of the law that such electronic record should be in electronic form or accessible for subsequent use and should be retained for specified period. Now, there is no requirement of law which compels the court to direct the party to preserve the electronic original record in the presence of admitted, exhibited secondary evidence for perpetuity. Now, in the case of Arjun Pandit Rao, Honorable Supreme Court, while being aware of this situation, that retention of some of the electronic records, especially the CDRs or other records which are seized during investigation, issued general directions to cellular companies and other internet service providers to maintain CDRs and other relevant record for the period concerned in a segregated and secure manner if a particular CDR or other record is seized during the investigation in the said period. The parties can then summon such records at the stage of defense evidence or in the event such data is required to cross-examine a particular witness. The direction shall be applied in all criminal trials till appropriate directions are issued under relevant terms of the applicable licenses or under Section 67C of the Information Technology Act. Other than the directions given by Honorable Supreme Court in Arjun Pandit Rao, there is no requirement for preserving the original record when the secondary evidence is duly exhibited, it is duly filed before the court, it is admissible in the evidence. Now, this question we also have is that whether forensic expert is required to give a certificate under Section 65B or 65B or not. Now, it is seen that at the time of filing the certificate or at the time of filing the report by the forensic expert, the same would also have the certificate under Section 65B of the forensic expert. Now, there is no clear-cut point on this law, but some light was thrown by Honorable Madras High Court in the case of K. Ramajayam versus alias Appu, and it was observed that the question of copy, as it is normally understood in physical data, may not be applicable on electronic data. While retrieving the data from youth server, it would be suffice if certificate under Section 65B is obtained from the person who is in charge of the server, and after so, the expert can feed the data into his computer and take printouts in tangible form with his certification stating as to how he collected the data from the server and produce the output. These two certificates would satisfy the requirement under Section 65B of the Indian Evidence Act. Further, there is an article by cyber expert Shri Vijay Shankar Navi at navi.org with regard to clarification of Section 65B with regards to the certification by forensic labs, and it was opined by the expert that if analyst has produced an extract of information of the electronic document as a part of his report and relied on such extract, then the certificate under Section 65B is required. But if analyst does not use any electronic document as a part of his report, and if he only gives his opinion, then he does not require a certificate under Section 65B. Another question that we often have is that whether it is necessary to examine the person in every case who had given the certificate under Section 65B before the trial court. Now, for that, I will take your attention to Section 65B, Subsection 4 Evidence Act, which says that in any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate. And for that purpose of this subsection, it shall be sufficient for a matter to be stated to be the best of his knowledge or belief or the person stating it. So if there is a certificate, then we do not require the person who has given the certificate to make the certificate admissible in the court during the course of evidence. It was also answered by Honorable Madras High Court in the case of K. Ramajayam that it is not necessary to examine every person who had given the certificate under Section 65B as a witness before the trial court unless court suspects the integrity of electronic record which is produced in evidence. One should bear in mind that a digital image cannot be easily manipulated. Every digital image has a metadata stored in it. The metadata is structured as coded data, gives every image truthfulness of the contents of the computer generated record, but is essentially related to the working condition of the computer where the stored record is produced and is in tangible form. So in conclusion, I would like to say that Section 3 of Indian Evidence Act, it gives us the definition of proved, and it speaks about the existence of act so probable that a prudent man ought, under the circumstances of the peculiar case, to act upon the supposition that it exists. The word here is a prudent man and not a hyper-technical man, which supposes that it exists. General principles of appreciation of the evidence, whether it is the oral evidence or the documentary evidence or the electronic record is concerned, will remain the same. We as judges cannot afford to be hyper-technical and should not be afraid to consider electronic record, which at the end of the day is nothing but a documentary evidence only. De omnibus dubitum, doubt everything, is the philosophy. It may be a road of scientific discoveries, but not for judicial inquiries, where perfect proof is an utopian. The celebrated jurist, late lamented Nani Palkiwala, commented, "Our legal system has made life too easy for criminals and too difficult for law-abiding citizens. A touch here and push there, and India may become ungovernable under the present constitutional setup. It is the time that we come out of an anachronistic mindset of suspecting and doubting every act of the police, lest the justice delivery system should become a mockery." So whenever an electronic record is produced before the court, we as judges should never be afraid of taking that record. We should always first see the relevancy, the admissibility, and thereafter rule upon the genuineness of that record. With these words, I would like to end my presentation. Thank you very much for your kind audience, and I shall not be able to take the question answer sessions because it is already late. So although we have received lots of your questions, and we try to answer all these questions eventually, all the presentations that we have shown here or presented, we will be sending you with a copy of the same, and so that it will help you in future for further deciding of the cases. So till we meet again, thank you very much for the patient hearing. Namaskar.